Good afternoon, and thank you for joining us. I'm just letting people join in at the moment because I think there's still people coming in from the lobby, so we'll begin in a moment. Just while we're waiting for all the people to join, could you just switch your microphones on mute, please? Right, we might as well start. If the noise keeps beeping, then that's just people joining, but hopefully everybody will be within the webinar quite quickly. Good afternoon, my name's Christopher McCauley. I'm a barrister at Guildford Chambers, and I specialise in chancery. Well, my practice is chancery, in particular probate and property matters. And at the outset, I'd like to thank you all for attending, well, for such a fantastic response we've had to the invitation for this webinar. And I hope that you'll all find something useful within it. Well, the way that the format of this webinar is going to work is that I'm just going to talk for the next probably 40 minutes to an hour. But if you have any questions, just jot down my email address and send them across to me. Alternately, I will be, after the email or after the webinar finishes, emailing you all just to say thank you for attending, which takes a very long time due to the amount of people that are signed up to the webinar. But if it's easier, you can just respond to the email and ask me whatever question that you want, as long as it's about the webinar, because quite often you get people asking you questions about their own cases, which I'm very happy to advise you on, but it would need to be on a formal basis. Now, in today's webinar, I'm going to primarily focus on Part 8 claims, which seek the appointment of a substitute personal representative under Section 50 of the Administration of Justice Act 1985. And what I'm going to look at in particular is the common themes that run through the Section 50 cases and how those common themes feed into the key consideration, which is whether the administration of the estate has been properly administered and the welfare of the beneficiaries. I'm also going to briefly touch on Section 116 of the Senior Courts Act and the Judicial Trustees Act 1896, but the discussion on these points is going to be much more limited. So if we move on to our first point, which is our first slide, which is in relation to the Judicial Trustees Act. As there's a mixture of people who have signed up for this webinar in terms of experience, I'm just going to start by covering some basics to make sure that everybody's on the same page. And by way of background, prior to the introduction of the Judicial Trustees Act 1896, there was no power to remove a personal representative who had been granted probate. And the authority, if you need one for that point, is the Victorian case of Re Ratcliffe. However, subsection 1, subparagraph 2 of the 1896 Act made it clear that the power under the Act also extends to personal representatives, and as such, a statutory power was introduced. Now, in modern times, the provision is not used very often, as it seems to be rather cumbersome and expensive when compared to, for example, Section 50 claims. But when I say Section 50, for the avoidance of doubt, I'm talking about Section 50 of the Administration of Justice Act 1985, but rather than just keep repeating that, I'm just going to refer to them as Section 50 claims. But the judicial trustees, judicial trustees can still be appointed, and the 1896 Act does still serve a useful purpose. As a party relying on a Section 50 claim has to either be a personal representative or, well, personal representative of the deceased or a beneficiary of the state. And subparagraph 5 of Section 50 explains that in this section, beneficiary the term beneficiary in relation to the estate of a deceased person means a person who, under the will of the deceased or under the law relating to intestacy, is beneficially interested in the estate. As such, Mr. Justice Lewison, as he then was, found in the case of Thomas and Agnes Carville Foundation in Carville, the party relying on a trust arising out of an agreement between two testators not to revoke their wills had no standing to bring a claim under Section 50, as the trust that they're relying on arises out of the agreement, and therefore they are not a person beneficially interested in the estate under the will of the deceased. However, a person claiming under the doctrine of mutual wills would be able to rely on Section 1 of the 1896 Act. In the premises, the application, well, Section 1 of the trust of the 1896 Act, its application is quite rare, but it does still serve a useful purpose. The next piece of legislation that we're just going to very quickly look at, because we're still discussing the priorities, sorry, the basics, is that you need to be aware of is Section 116 of the Senior Courts Act 1981. And Mr. Justice Newey, as he then was, explained in the case of Re Goodman that this provision replaced Section 162 of the Supreme Court of Judicial Consolidation Act 1925, which in turn had replaced Section 73 of the Courts of Probate Act 1857. And in very simple terms, if there are special circumstances which make it necessary or expedient for the applicant to be appointed as an administrator, then the court can exercise its discretion to pass over an executor. However, this jurisdiction is only available prior to a grant, and therefore the scope of Section 116 claims is much narrower than that of Section 50 claims, as the case of Re Goodman has held that Section 50 applies to non-proving executors as well as personal representatives who have obtained a grant. Now, I should probably expand on that point slightly, because there are a number of points that arise out of that call for a little bit of further explanation. The first of which, I'm not sure if you could see that or not, if it came up on the screen, but I got an email from Nando's which popped up, which hopefully didn't come up on the screen. The couple of points that need to be explained from that. And the first is that in the case of Perotti and Watson, Mr. Justice Rimmer, as he then was, had questioned whether Section 50 of the 1985 Act could apply to a non-proven executor. But in that case, he found it was unnecessary to determine the point. Now, on appeal, Sir Martin Norse had expressed the opinion that if an executor is named in a will and is not proved, then there is nothing to remove him from. However, against that background, with some hesitation, Mr. Justice Newey, as he then was, found that Sir Martin Norse's comments in Perotti were overture and not binding on him, and he found that Section 50 can be used to replace a non-proven executor, and that decision has been followed in a number of cases. And in fact, I had one in front of Chief Master Marsh where the claim related to a non-proven executor, and I currently have one that's going on at the moment that's due to be heard, also involving an application to remove a non-proven executor. The second point, however, that I should just pick up on in relation to Re Goodman is that what one needs to understand is that the reason why you can replace an executor, a non-proven executor, is because the executor derives title from the will. But that wouldn't apply to an administrator, because there's an obvious difference in the administrator obtains their title by virtue of the order of the court. So you can replace under Section 50 a non-proven executor and an executor who has obtained a grant, but you can only replace an administrator who has obtained a grant of letters of administration. So you can't apply it to an administrator before they've taken out a grant. Now, with all of these statutory provisions, the court has a discretion, and in particular under Section 50, there's a discretion that that the court will take. Well, the court will have to exercise its discretion as to whether or not to replace the executor. And in doing that, the court, although it has a discretion, will do so and it will exercise that discretion in accordance with established principles. And the overriding consideration for the court in Section 50 applications is the welfare of the beneficiaries and whether the estate is being properly administered. Now, as most of you will be aware, that principle comes from Lord Blackburn's speech in the Victorian Privy Council case by the name of Letchstead and Brewers, which of course is the leading case in relation to the removal of trustee claims. But as we know from a number of cases, such as Thomas and Agnes Carville Foundation in Carville, and also Kershaw and Micallef, the same principles apply to the removal of executor claims. Another one is Dobson and Hayman, where it was accepted that it would apply. And what Lord Blackburn means in this test that he was putting forward, I think is actually very neatly encapsulated by Lord Justice Patten in a case known as Re Savile's estate, which is also known as NatWest and Lucas, where he stated that the direct intervention by the court in the administration of a trust or the estate by the removal of the trustee or personal representative has for the most part to be justified by the evidence, and their continuation in office is likely to prove detrimental to the interests of the beneficiaries. A lack of confidence or feelings of mistrust are not therefore sufficient in themselves to justify removal, unless the breakdown in relations is likely to jeopardize the proper administration of the trust or estate. There is something which requires to be, which requires to be objectively demonstrated and considered on a case-to-case basis, having regard to the particular circumstances. Now, there are a number of themes in that passage that one could pick up on, but the key theme, in my opinion, is Lord Justice Patten's statement that the removal needs to be justified by evidence that their continuation in office is likely to prove detrimental to the interest of the beneficiary. And that point really is key, because what you have to look at in these cases is you have to look at the circumstances and see if those circumstances are sufficient to disrupt the proper administration of the estate. Now, at this juncture, it would be quite natural to discuss the relevant threshold that applies to Section 50 claims, but I'm deliberately not going to do that, and I'm going to discuss it later. And the reason for that is that I think that there has been a slight misinterpretation of the threshold in recent years in certain arguments, and what you really need to do is look at the common themes first and then consider the threshold, because once you do that, the threshold becomes a lot, well, it becomes illuminating as to what the threshold actually is. So what we're going to do is we're going to turn to the common themes, which is the key thing that I want to look at in this webinar. And the first common theme that we're going to look at is breach of duty. Now, this is a point that can be dealt with quite quickly, because as you can see from the slide, Lord Blackburn in Letchstead was cited with approval a passage from Story's Equities Jurisprudence. And Mr. Justice Newey stated in the case of Kershaw that the point would equally apply to an executor. Now, from that passage, it will be evident that not every breach of duty will result in the removal of the executor. Therefore, what Letchstead suggests is that the court should be concerned with the gravity of the breach and whether it puts the estate's property in jeopardy or affects the administration of the estate or the welfare of the beneficiaries. Now, the problem with this is that the court in Section 50 claims is unlikely to make findings about whether or not there's been wrongdoing. And And as Chief Master Marsh has pointed out in Schumacher and Clark, the removal claims tend to be a precursor for another action. Further, as Section 50 claims are Part 8 claims, the general position is that there's no cross-examination. But having said that, although there are a number, particularly of Chief Master Marsh's decisions saying that there shouldn't be cross-examination, for example, Schumacher and Clark, there are numerous cases where the court has allowed cross-examination, particularly in relation to the earlier cases, but there was actually one last year, or sorry, this year, where it also allowed cross-examination. So the significance of breach of duties, in my opinion, in the context of removal claims is twofold. Firstly, if it is obvious that the breach is fairly minor, then it's probably not going to trouble the court much, and then it will. And to provide some context in relation to this point, what I mean by this is, well, if you look at, for example, Mr. Justice Newey's statement on the slide, he was making that statement in relation to a delay in supplying estate counts. So you can get an idea of the type of breach that he was envisaging when he was making that statement. But the second point, which in my opinion is much more important, and is, if you're going to take one thing from this webinar, it would be this one, is that the court's not going to determine whether there's been wrongdoing. But if there appears to the court on the evidence that's been provided that the allegations of wrongdoing have a reasonable prospect of success, and that there needs to be an investigation into those issues, then it's going to be, in most cases, it's going to be in the interest of the beneficiaries for the executor to be replaced due to the obvious conflict of interest. So pursuant to that, there is no need for the court to make a finding of wrongdoing, as it's the conflict that means the executor should be removed. And a lot of modern statements, in particular those made by Chief Master Marsh, need to be understood with this point in mind. Well, at least in my opinion, they do. And an example of this point as to this point about the allegations giving rise to a conflict can be seen in the case of Folks Estate, which is otherwise known as Griffin and Higgs. Now, as to our next slide, which should be conflict. Yep, it is. There are a number of ways in which a conflict between the executor and the beneficiaries could arise, and the most probably the most obvious example of this would be where you have where for example, an executor is indicating or does bring a personal claim against the estate. And there's an interesting example of this in the case of Heath and Heath, where there were, in that case, there were three brothers. All had been appointed under the will as executors of their late mother's estate, and all had, I think, two of them were doctors, and but in any event, there was one of the brothers who had cared for the mother and sought to challenge the validity of the will, saying, well, he didn't seek to challenge the validity of the will. What he sought to challenge was that there was, he was saying that it wasn't the last will, that there was a further will. However, they didn't have any evidence of that, and the court rejected his argument on that point. But the point which is of interest to what I'm talking about now is that he indicated, he was very clear that he was going to bring a claim for, under what he framed as implied contract or possibly quantum merit, against the estate for him caring for his mother. And by virtue of that, the court found that there was a conflict between him and his role as executor and his personal interest, and that he should be removed. Another interesting example another example where you see that where there was a conflict arising by virtue of somebody having a personal interest can be seen in the case of Thomas and Agnes Carville Foundation Business Carville, where there was a conflict of interest in that the personal representative in that case brought proceedings in the High Court for a personal claim against the estate. Now, I've also mentioned on the slide Re Wheatman, and the reason why I put that on the slide is that this case is usually relied on to argue that the potential of a conflict is enough to remove a party. But with that point, what you need to remember is that the argument always has to relate back to the test. Therefore, if you're seeking to rely on a potential conflict, what one has to consider is whether the potential conflict will have an impact on the welfare of the beneficiaries, and on whether there is ways in which it could be managed. Finally, also on the side, there is the case of, there are a number of cases that I'll come to, but there's the case of Caldecott and Richards, which I should also just briefly touch on. Now, this and also Re Wheatman were cases involving claims for the removal of trustees, but the same principles apply to the, as has been established in numerous cases, the general same principles apply to the two types of claim, to removal of the executor and removal of trustee. And what's interesting in the case of Caldecott and Richards was that in that case, Mrs. Justice Falk acknowledged that the trustee was in a potential position of conflict because she wanted, it was to do with, there was a point to do with that she wanted to have the business, she wanted to keep the business going and so forth, which potentially created a conflict. And what was interesting was that Mrs. Justice Falk placed weight on the fact that the settler must have known and intended the inherent conflict. And she took into account that factor and no other factors to find that the trustee shouldn't be removed. Therefore, the point, put very simply, is context will be key in relation to conflicts. The next key theme that you commonly see, or the next theme that's commonly raised in these type of cases, is whether there is friction or hostility between. And there's two ways that this can arise. You can have friction or hostility between the executor and the beneficiary, or you can have friction and hostility between the executors. And quite common, as you'll all be aware, you'll have a situation where the beneficiaries are also the executors. But you'll see from the slide that friction in itself is not enough to remove an executor. Therefore, if you're going to mount an argument based on friction and hostility, what you need to do is show that it's going to impede the administration or some way affect the interest of the beneficiaries. And an interesting example of an executive beneficiary type scenario can be seen in the case of Kershaw and Micklethwaite. Because in that case, Mr. Justice Newey held that poor relations between the parties would not prevent or impede the administration of the estate. And what was quite interesting, he actually used the word would not impede substantially the administration of the estate. So he kind of did envisage that there would be some impediment, but it wasn't substantial. As such, he went on to conclude that the matters relied on by the party seeking removal didn't suggest that there'd be any real risk in relation to the welfare of the beneficiaries. And there's also an interesting case, which was subsequently appealed, which is Re Savile's estate, which is also known as National Westminster Bank and Lucas. And the first instant decision came before Mr. Justice Sales. And in that matter, he pointed out that there will be times when a personal representative has to strike a balance between competing interests, and the decision he or she makes may adversely affect a party. And in those circumstances, an element of friction may arise, and the person affected by the decision, between the personal representative and the person affected by the decision. But if the personal representative is acting properly, then the friction is not a good reason to remove the personal representative. And in that particular case, what the PR was having to do was balance the interests of the claimant, of a group of personal injury claimants who were bringing a claim against Jimmy Savile's estate, with the interests of beneficiaries under a trust. And another interesting case, which is quite recent, is the case of Hudman and Morris. And in that case, the court acknowledged that a poor relationship between an executor and beneficiaries was insufficient in itself to remove an executor. However, the executor in that case has shown significant hostility towards the beneficiaries, who were largely his siblings. And in light of that, what the court found, and I think they were right to, found that he wouldn't be able to look at look at issues concerning the beneficiaries' entitlements objectively or in a reasonable way. And that meant that which was necessary, of course, for the proper administration of the estate. The next point that to consider, or the next theme that will usually be considered, is Actually, sorry, just before we go on to the cost point, another point I should actually just very briefly make is a very common type of argument that you see in these type of cases is you'll see a situation where A says, "Oh, I've fallen out with B," and A and B are siblings, and says, "Oh, I can't work with B due to that falling out." Now, what's important when you're looking at that situation is to look at whether or not what's being alleged is genuine or not, because quite often the falling out can be quite manufactured. But if they genuinely can't work together, then it's clearly going to be in the welfare of the beneficiaries, or the welfare of the beneficiaries is clearly going to dictate that either one or both of them is going to need to be removed so that the estate can be properly administered. And there are a number of cases where you can see that where that's happened. So in the case, there's a case of Riley and Seed, which involved, if memory serves me correctly, 3 sisters, where 2 of them had fallen out with one of them. Another case is Pesci and Allnut, and in a trust context, there's an interesting case by the name of Scott and Scott, which involved 2 brothers who had fallen out, and one of them was a commercial partner in a law firm. However, when you're looking at this point about hostility, as I was saying before, it's going to have to be viewed, because a lot of these factors overlap, and it's going to have to be viewed in the context of a number of different factors. And the decision of whether you're going to replace one or both of them, if A and B are fallen out, is very likely, is going to depend on a number of factors, which would include the cost of appointing a third-party representative, the value and size of the estate, and also what's left to be done with the in relation in terms of the administration, which takes us nicely onto the point that our next slide, which you already have, which is the cost point. And this, in my opinion, is an important point, particularly where an estate is modest. And you'll see from the slide, in particular, Chief Master Marsh's comments in Harris and Earwicker, that the additional cost of replacing some or all the personal representatives, particularly where it's proposed to appoint a professional person, is a material consideration. The size of the estate and the scope and cost of the work which will be needed will have to be considered. Further, it is also worth noting Deputy Master Linwood's logical comments in Brief Folks, which were put very simply that the cost should not outweigh the gain. You'll also, with regards to, if I just briefly go through the other cases on the slide, the first one is Kershaw and Micklethwaite, which was a decision of Mr. Justice Newey. And in that case, he found that cost would be a factor weighing against the removal of the executor. In Caldecott and Richards, that was a removal of trustees claim, but in that case, Mrs. Justice Falk held that the fact that the trustee didn't charge for their time was a material point that the court should take into account. And in relation to Hudman, Hudson and Morris, which is from this year. There's quite an interesting point that comes out of that case, because in effect, Master Clark flipped the argument on its head and decided slightly what is the reverse from what's usually argued. Usually, where there's not much left to do, someone would say, the advocate for the defendant would say, well, it's going to be disproportionate because there's going to be reading in and so forth, and the cost is going to outweigh the benefit, and you don't need to be disproportionate for the cost for the court to order that. However, Master Clark found that as there wasn't much to do, the cost would actually be quite, the cost of a competent solicitor would actually be quite minimal, so that he found against that argument. But I do think, well, Master Clark found against that argument, but I do think that the decision, the statement, that the decision went a little bit too far, because what Master Clark went on to state was that the cost of a competent solicitor would clearly be outweighed by the costs of the proceedings, which is a factor that the party should have taken into account. But that, with the greatest respect, applies the benefit of hindsight, which isn't a material consideration. What you need to be looking at is whether it's in the interest of the beneficiaries at that time for the executor to be replaced. So although you can take into account past factors, I don't think the cost of those proceedings outweighing the cost that are going to have to be incurred in any event if you appoint a third party is necessarily a good one. However, it is an interesting case because it flips the argument, essentially. The next point or theme that I just want to briefly touch on is in relation to what's left to be done in relation to the administration of the estate. And this point is pretty straightforward. As if the administration is almost complete, and the argument is usually that there is, as I was saying before, that it'd be disproportionate to replace the executor. Further, it's usually argued that there's no real point in replacing the executor, especially if the principal complaint is that there's been a delay in administering the estate because they've got their act together and they're actually progressing it. And on this point, it's worth having a look at a case called Knowles and Feld, because in that case, there was an impasse in the administration and the claimant had made various complaints. Now, what was interesting in that case was the deputy master in that case concluded that what was in everybody's interest, concluded that it would be in everybody's interest for the estate to be administered, and opposing the administration was illogical because one of the parties was saying that they were seeking to oppose the administration moving forward. So therefore, considering the advanced state of the administration, he found that appointing a professional administrator, or the learned judge in that case found that appointing a professional third-party administrator, third-party executor would be wasteful of costs. And there are a number of cases which where judges have expressed similar guidance on this point. For example, in Kershaw, Mr. Justice Newey stated that he inferred from Lord Blackburn's decision in Letterstead that if what's left to be done is of a simple character, this would weigh against removal. And in Scott and Scott, which was a case that a trustee removal case, the court again took into account the fact that what was left to be done was quite straightforward. And if there was any complexity that arose in that case, then the remaining executor would be straightforward for the remaining executor because he was a partner in a law firm. There's another interesting case, which is Haynes and Andre. And this case is interesting for a number of different reasons, which one of them goes slightly off topic, but I'll just mention it briefly. The first reason why this case is interesting is that unfortunately what happened was that the claimant died in between the hearing and the handing down of the judgment, but the learned judge in that case held that they still had jurisdiction to exercise their discretion. Now, what what was the second point that was interesting was that there was concerns raised by the claimant that about because it was a brother and sister about the defendant, and they were both seeking the removal of a third party who had been appointed, but they clearly didn't get on. And what the court decided in that case was that they were going to appoint the defendant because she had been named as a substitute in the mother's will, substitute executor in the mother's will, and they gave particular weight to the fact that she had been named as an executor in the mother's will. But also, what was interesting in that case was that the court took a practical way forward in finding that, because it looked at what was left to be done with the estate, and largely all that was left to be done was the marketing and sale of a property. And what the court decided was that, well, she could act as the executor, and any concerns that the claimant's family might have could be alleviated by the court directing that the sale take place under the direction of the court. And clearly what the court had in mind in doing that was that it would be much cheaper than appointing a third party. And that's an interesting practical solution that was applied. However, again, everything's going to depend on context. And there are a number of cases where the court has noted that there's not a great deal to do, or that the works of a simple character. For example, in Riley and Seed, the court noted that the task in front of the executors was a simple character, but found that didn't really matter because in that context, because the executors just simply couldn't work together. So that outweighed the other factors. Now, another key argument, or another key theme, at least in my opinion, that you see in these cases is the testator's choice. And this argument commonly comes up. The argument that commonly comes up in relation to this is what weight should be attached to the testator's choice and the beneficiary's wishes. Now, in my opinion, the testator's wishes are clearly a significant factor that should be taken into account by the court due to the notion of testamentary freedom and the emphasis that we place on that in all areas of probate. For example, a testator can be capricious and they can be ungrateful and so forth. So it's a key, in my opinion, it's a key point. And in the case of Kershaw, counsel in that case was seeking to argue that the testator's wishes was an irrelevant consideration when one considered the overriding consideration of the welfare of the beneficiaries. And Mr. Justice Newey in that case rejected that argument. And the reason why he rejected the argument was that he found that a testator's choice of executors is capable of being of relevance because the testator will be expected to have known, to have knowledge of the characters and attitudes and relationships of the parties, which the court will lack. Now, it's interesting that he shoehorns it into the relevant test rather than saying it's an independent point that the court should take into account, because if you apply it as part of the relevant test, there are a number of different arguments you can get into, and as will come apparent in a moment, in relation to the cases, which are about whether what inferences can be drawn from the relevant evidence. And if you and this point is probably best demonstrated if I go through a number of the cases. So, for example, in Reeve Folks, in that case, Deputy Master Linwood, citing the case of Alkin and Raymond, which, if memory serves me correctly, was a decision of Mr. Bumpus QC, sitting as a Deputy High Court Judge. for the proposition that the court must have regard to the fact that the testator specifically chose their executor, and therefore there has to be a good reason for the court to interfere and remove the executor. Again, in Harrison Earwicker, Chief Master Marsh placed particular weight on the fact that he had a clear impression that the testator had thought about who he wished to appoint as executors, and as I say, placed weight on that. And as I was saying before, in the case of Haynes and Andre, the court noted that the defendant had been listed as a substitute executor in the will and gave weight to that fact. However, one can see in the case of Nat Weston Lucas, which is re Savile's estate, that the court didn't, or Mr. Justice Sales in that case, didn't place much weight on the testator's choice, as in that case it had just been a bank. And more recently in Hudman and Morris, Master Clark found that where the court noted the court's the relevance of the deceased's wishes, but stated that they could not outweigh the factors supporting the removal. So it's quite clear from those cases that this will be a factor that's taken into account in the balance. And what's going to be significant is the inferences that are drawn from the evidence as to whether or not the testator has chosen those people for a particular reason. For example, if she was to have 3 children and one of them was overbearing, it would be a significant factor that one of them had been excluded. Presumably the executor would be doing so in order to try and further the administration of the estate, because they've realised that if the third one was included, the problems would arise. So these are factors that one would have to take into account in assessing, and you can see that they stem from the test or the incorporation of this factor into the principal overriding consideration of the test. Now, with regards to beneficiaries' wishes, this can be summarised quite quickly, and is actually neatly summarised by Master Clark in Hudman and Morris, which, if I paraphrase, the point was made there that beneficiaries can't demand the replacement of a personal representative, but their unanimous views are important when considering their welfare. And it's very neatly summarised by Master Clark there. Now, as we've gone through the common themes, now I want to look at the threshold, because you have, hopefully, you have the background information to understand the threshold, to more accurately understand the threshold. And it appears to be suggested, or at least that there appears to be some argument recently, that as a result of some of Chief Master Marsh's decisions, in particular Schumacher and Clark and Long and Rudman, that the threshold is quite low in removal claims. However, I don't think that's accurate. And the reason for that is, as I've previously said, Chief Master Marsh's comments have to be viewed in context. And the context in which they have to be viewed in is that if a party makes allegations which have a reasonable prospect of success, then the executor is going to be put in a position of obvious conflict, and it's going to be in the interest of the beneficiaries for those allegations to be investigated. And it's the conflict which means that they should be removed. Now, one could theoretically try and argue the opposite by relying on the case of Free Wrightson, but there are clear practical reasons as to why, in that scenario, executors should be removed. Further, I respectfully suggest that if one considers Chief Master Marsh's decisions, a number of his decisions, and in particular those 2 cases, he refers to Harry. Well, if you look at his case of Harrison Earwicker, you'll see that Chief Master Marsh there stated that the jurisdiction under Section 50 is not to be exercised lightly, and although there is no presumption, I should say is no presumption, against change, the party seeking the change must satisfy the court that there are substantial grounds which make a change necessary. And that's significant. And also, if one looks at the case of Reeve Folks, You see, in that case, Deputy Master Linwood described removing the executor as a drastic step. And if we go back to the slide that we were looking at earlier on, which is taken from Bree Saville's estate in the Court of Appeal, Lord Justice Patton's statement in that case was that Lord Justice Patton made it very clear that the removal must be justified by evidence that the executor's continuation in office is likely to prove detrimental to the interests of the beneficiaries. Therefore, these factors would, in my opinion, suggest that the test is, it is not as, well, is higher than some people think it might be. Now, you have 2 points in relation to, you have an initial consideration of whether an executor should be replaced, and then after that decision has been made, you have a second point in these types of claims, which is to consider whether, consider who should replace them if you've decided that they should be replaced. And when you're preparing your case, you need to, if you're going to rely on a professional replacement, you need to make sure that you've got your house in order, so to speak, because you're going to need consent from that person to act. You're going to need evidence setting out the details of their experience of charge and rates. And you're also going to need, under the Chancery Guide, you're going to need a witness statement for somebody who attests to their fitness to act in their work. And there's an interesting case, a couple of interesting cases in this area, because one point that you quite commonly see is you'll see somebody suggest that their solicitor should be the one that acts. Clearly, that's not going to be appropriate. And in the case of Knowles and Feld, the point was made in that case by the Deputy Master that the solicitor was unlikely to be independent. However, if you are going to appoint a third party, then the court is going to need evidence. And the evidence I was saying before, and there was an interesting case in 2020, which is Re Lu, which looked at the different factors. If I remember correctly, it was a decision of Deputy Master Linwood, which looked at a number of different factors that would need to be taken into account in assessing who was the appropriate third-party professional to be appointed. So in that case, the claimant was suggesting one person, the defendant was suggesting another. And what the learned judge looked at in that case was the knowledge and experience of the two people, then looked at their availability to take on the work, also looked at their location, the nature of the estate and the complexity in relation to it, took account of the beneficiary's wishes. But the key point and the determining point, because the judge found that the parties that were proposed had similar experience, was the cost, and found that the cost was a determining factor. So that's quite a useful case. Finally, just before I close this presentation, I would just like to say that in these types of cases, emotions are usually running quite high, but in any type of litigation, the emotion always needs to be taken out of the case, and people need to look at things practically and commercially. And it's important that is explained to the clients that, for example, Johnny wasn't involved in looking after mother, isn't going to be something that the court's interested in. What we have to look at is the key points or the key themes to see how they affect the test, and look at the facts and circumstances of the case as to whether or not somebody should be removed. Now, that concludes the presentation, and I'd like to thank you all for attending. As I was saying before, I will email all of you, which is going to take me a considerable amount of time, but I will start to email you this afternoon to thank you for all attending. So if you have any questions about the webinar, or there's something you'd like me to clarify within it, then please just drop me an email by return, or if you just want to say hello, it's always nice to get a response. Okay, thank you very much for attending. Bye.